You're entitled to a copy of just the search warrant, not the affidavit, just the search warrant.
At some point, but not at this point necessarily.
Well, can you explain that to me? Because if I sign a search warrant for someone's home, and BSO goes to their home and executes the search warrant, and they're there, they give them a copy of the search warrant.
Correct. But
Upon
in
its
this case,
execution.
It's Apple that the warrant is being executed upon, not the party themselves.
And you think your authority says that she's not even entitled to a copy of the search warrant?
Yeah, that's correct, Judge, yes.
That's your position?
Yes, Judge.
Okay. Okay. Well, over the state's objection, I'm ordering you to turn over a copy of the search warrant. I'll put that in a written form today, so you can litigate that as you see fit. But I certainly think she's entitled to a copy of the search warrant. Probably that's it at this point. So, defense, I'm happy to hear anything you want to tell me, but based on our discussion yesterday, I think where we're at is I need to give you a date very soon in the future, a date in February, which is what we're looking at. And at that point in time, you're going to have to come back in here and tell me, and I'm going to have a discussion with Mr. Demons. I'm going to start that discussion this morning so he understands that he's the captain of the ship. This is his decision, but he's going to have to tell me if he wants Ms. Liberty to continue to be his lawyer or not. He's going to have to tell me if he wants all of you to continue to be his lawyers or not, or he's going to have to tell me that he's going to seek other counsel, but I think that needs to happen sooner rather than later.
We concur with that issue. I'm confused, and I apologize to the court. Is the court entertaining this motion for reconsideration and not?
There was no motion or ruling. I think she's entitled to I think, listen, Mr. Demons is entitled to heightened due process. The state
Yes.
is seeking the death penalty. It is very clear that one of his lawyers is under investigation right now.
Okay.
He is entitled to have as much information as I have the ability to give him before he has to make a decision. Is there a conflict of interest? Does he want to waive that conflict of interest and continue with that lawyer as part of his representation? Or does he not? Does he want the lawyer to withdraw? And again, the Florida Supreme Court has been very clear on this. He's the captain of the ship.
Absolutely.
He makes this decision. So if there was, again, I'll repeat what I said, I think, to Mr. Aronson yesterday, if you all had some other authority that says I have some additional power to assist in the fact-finding here, I would hear what the state has to say about it, but I would probably be inclined to do that. But my inherent authority, or citing the U.S. Constitution, although I very strongly believe in the U.S. Constitution, this is a, I'm not involved in this. The underlying facts that are going to make a determination is whether there's a conflict and what Mr. Demons wants to do. This is completely 100% a decision between himself and his lawyers. I don't have anything to do
We're
with it.
not disputing that.
So I don't know what else I can do at this point. You've asked me to press pause on all these motions. I'll press pause. I'm not going to move his trial date. His trial is going forward in September. So if
Judge.
these motions are heard next month, or they're heard in March, or they're heard in August, or they're heard contemporaneously during his trial, which again would not be the
Correct.
most ideal way to do things. If that's what ends up happening, that's what ends up happening. But the one thing I can tell you is not going to happen is someone that has been in custody for 2,160 days, his trial is not going to be delayed under any circumstance. So that being said, what else would you like me to do this morning?
Well, a couple things. Since the state filed a motion for rehearing, there are misstatements in their motion that need to be corrected. Since we received this early this morning and saw it for the first time, we did not file any written plea of response. And if I may, just go through the corrections that we saw. It's on number 1, it says the search warrant was issued in December of 2024. It was 23, not 24, a year earlier.
We agree with that, Judge. That way, yeah.
In paragraph number 2, they said that the state disclosed an ongoing investigation to Miss Liberty. That is absolutely untrue. We learned of it through Apple. They confirmed it yesterday for the first time, over a year after the search warrant was executed. Paragraph number 5. indicates that this investigation is separate and apart from the defendant's current case. It conflicts with paragraph 11 that implies that this investigation is related to the tampering case of Mr. Demons. Is it unrelated or is it related? I think the court needs to know that, because if it's related, I believe, and we will file a written response under discovery, he's entitled to that information, anything that leads to relevant and important information. And I'm not asking the court to rule on it at this point, but I want the court to know that if it's related to his present charges under 3.220, we're entitled to that information. They make a statement that regardless of what Mr. Demons wants and is willing to waive the conflict, they believe that Ms. Raven must get off the case, regardless of that. That's their assertion. They have to prove it. And I want to put the court, the state, on notice that they must prove it. They can't merely allege that the conflict is so extent that even if this young man wants to waive it, they're going to come in here and say she must get off the case. That's what they say in this plea in paragraph number 11. That's a question for the court to determine, and they have to present evidence of that fact. We are still under the same impression that we don't have enough information. Pursuant to Your Honor's request, Mr. Aronson and I spoke to Mr. Demons. I call him Melly if the court will allow me.
I'd actually prefer that you use...
Mr. Demons?
Yeah.
Fair enough.
Thank you.
Mr. Demons, we discussed the potential of that. And if the court accepts my representation, or the court can inquire from him, he informed us that he doesn't have enough information to make that decision.
You're talking to me about privileged communication.
Well,
I'm going to talk to Mr. Demons at the conclusion of the hearing this morning, everything that I'm allowed to talk to him about. I don't want to hear about anything that you all talk about.
I was just willing to proffer his statement of that fact. And we would, of course, ask the court to deny their motion for rehearing and rule consistently with what you ruled yesterday, that they not only have to produce the search warrant, but the affidavit.
Well, do you want to respond to any of the case law they cited about ongoing investigations? That would relate to the affidavit.
Well, it relates, if it's related to his present charges under Rule 3.220, they must turn it over. So let them come in here and make a representation that it is either unrelated, totally different, or if it's in fact related, he has a right to see that information. And 3.220 is clear on that. Anything that could lead to relevant information must be disclosed. Judge, there is one other matter that we need to go sidebar on.
Okay, well, hold that, pause on that till then. State, is there anything else that you want to tell me today? The only thing I'm going to do is talk to Mr. Demons about the front end of this colloquy, if you will, and then give you a future date, which I'm looking at is February 18th. That's the day before my next trial starts, after the trial that's starting tomorrow. And on Tuesday, February the 18th, what I'm also going to ask each side to do is, if there's any motion pending that you think I can hear that is not interfered with by the pending matters that are up on appeal at the 4th DCA, state if you have anything that you want me to hear on February 18th, just file a notice of hearing and identify the motion you want me to hear. Defense, if there's anything else you want me to hear on February the 18th, just file a notice of hearing and identify what it is you want me to hear. I anticipate the murder trial that I'm commencing tomorrow will be done by then. It may not be, but I'm hoping that it is. And if it is, then I'll give you the whole day on February the 18th to address this issue regarding his representation. And if it turns out we can go forward and hear some of these pending matters, then I'll be happy to do that too.
Judge, I can just ask, I know you said file a notice of hearing, if we could have a deadline like by February first, so we don't end up in the same position we did this time where it was filed, three business days
Well,
before.
let's see, we're talking about February 18th, so how about the end of business on February the 7th? How about that?
That's fine,
All
Judge.
right, so that goes for both sides. If there's anything you want me to hear on February the 18th, just file a notice of hearing, identify exactly what it is that you want me to hear. And I'm gonna see him February the 18th at 9:30 a.m. Again, we'll call it all pending motions. Maybe we'll be able to work all day, and maybe we'll be able to do nothing. I guess that's really gonna be up to you all. State, is there any other requests that you have this morning?
Yes, Judge, as to the search warrant itself that Your Honor is going to compel us to provide, I'd ask that we have until February 1st, just so we have time to pursue the appellate remedies in the meantime, and then I'd also ask that it provide it to Your Honor in camera first, because it's the state's position that there are, even in the search warrant itself, certain things that make reference to other targets of the investigation, which are confidential, privilege, and would jeopardize the investigation. So we would ask that Your Honor review that in camera, if any necessary redactions have to be made, and then it can be provided to defense.
We would object to that procedure, and they've had a year, over a year, to produce these documents, so it's no surprise. We would ask that to be given to us by the end of tomorrow.
Okay, so listen, over the defense objection, state, this is what I'll do. I'm ordering you to turn over a copy of the search warrant. I need you to get that to me. A week from today, that's January 14th. End of the day, January the 14th, that comes to me,
Yes, Judge.
and then I'll review it, and then I'll distribute it as I see fit. I can't imagine there's anything in there I'm gonna redact. I mean, it doesn't matter, the state's free to investigate whoever they want for anything they want. To do this in the midst of a capital case, state, I realize some things are gonna happen that you might not find ideal, but that is of your doing because you've chosen to do this in the middle of a capital case, so. Mr. Demon's heightened due process rights will take precedent over every other matter in this case, obviously. So that's just the way it's gonna have to be, but I'll grant your request over the defense objection, at least as to that. Ms. Wilcox can give you a blank order, you can fill it out this morning, I know it's over the defendant's objection, but show them the order, and I'll be happy to sign it. The search warrant comes to me within 1 week,
Yes,
and
Judge.
then I will review it in camera, and then I will distribute it accordingly, as I see fit. State, anything else you want me to do this morning?
The judge.
Defense, besides your matter that you want to talk to me about, sidebar, anything
Yes,
else you want
since
me to
you're
do this
going
morning?
to, in camera, review the search warrant, we would ask that the state submit the affidavit.
Well, the case law seems pretty clear that you're not entitled to that, but if you have some competing authority, I'm happy to vote on
Yes, sir.
it.
Your Honor, on another note, I was a little confused yesterday as to whether or not you have lifted the stay as far as discovery, and we can start discovery again on everything, or we're still under that stay order? Just asking for
I asked both sides if you wanted to do that. I thought you both told me that you did want to do that, that you wanted to do the things that you can do.
I want to do everything,
I agree with you.
but
Time is short, but,
the state is the one that asked for the stay.
well, state, what do you want me to do?
Judge, we need to speak with the Attorney General's office, because we have that stay for a reason with certain things, but we have plenty to do
Outside of that.
outside of that first, so. we
Okay,
have
well,
some-
why don't we do the things that we all agree we can do? So the answer to Mr. Anderson's question is yes, without objection from either side, the stay is lifted to the extent that we can litigate any matter that's not currently before the
Well,
court.
no, we are objecting to that, Judge.
That was already done by Judge Murphy.
Right, that's already been
Judge
done.
Murphy already lifted the
He
stay.
As to-
modified it.
right, he
So that
modified
we
it.
could do
Oh,
ongoing discovery
okay.
as to things that were not up on appeal.
Okay. Again, if one side notices something for February 18th, and the other side thinks that that is included in the matters that cannot be handled because it's currently at the 4th District Court of Appeals, I'm sure you will file a written response and let me know that. And I guess I'll have to make a decision whether I agree with you or whether I don't. Defense, besides the matter that you want to talk to me about, anything else?
Judge, the only thing I would like to have you possibly consider is that you had said you were prepared to ask Mr. Deming some questions right now. I'm a little concerned that with the lack of information that exists in this case, for him to even opine on where to go right now, Based on what? The paragraph in their motion that says that he has to make a decision now because we told him there's a conflict. Doesn't rise
I'm not
to-
gonna ask him any questions. I'm just gonna explain to him the choices that he's made. No different than a defendant deciding to testify or not testify at a trial. I'm not gonna ask him any questions. I'm telling him what's coming. Because at some point, he is gonna have to tell me what he wants me to do.
And of course, we're gonna object at this point, and until the time that he's fully informed as to what there is that may be a conflict, he is in no position to answer, to make an opinion as to whether.
I'm not asking his opinion. You're objecting to me talking to your client about his rights?
It depends on what you say, Judge, but I am prefacing what your comments are because I was under the impression that you were gonna inquire with him as to whether or not that he finds there's a conflict.
No, I'm not.
Okay, great.
I'm not. Okay, again, so the record is crystal clear on this. I'm following this procedure pursuant to a case called Figueroa, Figueroa hyphen Sanabria, Sanabria versus State. It's a Florida Supreme Court case from 2023. It's found at 366 Southern 3rd, 1035. And this was a death penalty case as well. I'll quote what the Florida Supreme Court quotes. In all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. All competent defendants have the right to control their own destinies. He's entitled to his constitutional right of assistance of counsel, and there's nothing that makes him relinquish this right. So all I'm going to do this morning is explain to Mr. Demons that at some point this is going to be his choice. I'm sure his lawyers will give him their best advice, but this is going to be his decision. And he may not agree with your advice at some point, just like a defendant may decide to testify or not testify and not follow a lawyer's advice. But I take this decision to be the same way. It's a fundamental decision. This is a client decision. This isn't a lawyer decision. So, Mr. Demons, raise your right hand for me. You don't have to stand. You're okay. You can sit. You swear to tell the truth, whole truth, nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Please state your full name.
Chanel Maurice Jim,
How old are you?
25.
How far did you go in school?
I graduated, well, I got my own GED.
Do you read and understand the English language?
Yes.
Are you presently under the influence of any drugs, medication, or alcohol?
No.
Have you ever been treated for a mental illness?
No.
Are they giving you any medication in the jail right now?
No.
How are you feeling this morning?
Confused.
I understand. I'm a little confused myself. Your head is clear? You're not hearing voices. You
No.
hear your lawyers. You're talking to your lawyers. You understand what's going on this morning?
Yeah.
Okay. All right, so Mr. Demons, here's the deal. You're, just like any other defendant, you're entitled to have a conflict-free lawyer or lawyers representing you. Okay, a lawyer that has your best interest in mind to the exclusion of anything else. You with me so far?
Yes.
Okay. The state has told you that one of your lawyers is currently under investigation. For what? I have no idea. But there's some ongoing criminal investigation. Okay? You with me so far?
Yes.
Okay. So, this, what your lawyers correctly pointed out yesterday, raises immediately what we call a conflict of interest. In other words, maybe at some point during this litigation or some point during the trial, my lawyer's not going to do what's the best thing for me, my lawyer's going to do what's the best thing for my lawyer. And your two interests are separate. You understand that?
Yes, sir.
Okay. So, once your lawyers have had the opportunity to investigate all this, to get you all the information they can possibly get, so they can talk to you about all this, at some point, you're going to have to make a decision about who you want your lawyers to be going forward. You with me on that?
Yes.
Okay. Even if there is a conflict, you can waive the conflict if you want and say, Judge, I understand there's a conflict, but that's okay. I like these lawyers. They're doing a great job for me. They did a great job for me in the past, and I don't want to change, lawyers this late in the game. You understand that?
Yes.
Or you could likewise say the opposite and say, Judge, I don't feel comfortable with this. I think there's a conflict. I don't think Miss Liberty should be my lawyer anymore. I don't don't think any of my lawyers should be my lawyer anymore. And I want to go get some new lawyers. And if you want to hire your own lawyers, you can go out there and hire anyone you want. And if you want me to appoint lawyers to represent you, you would have to file an application with the clerk's office. And if they find that you're financially qualified, I could appoint lawyers to represent you. You understand that?
Yes.
The whole point I'm trying to make with you today, sir, is that this is going to be your decision. Your decision. Your lawyers will give you their best advice, and you have some excellent lawyers, okay, about what they think you should do. But at the end of the day, you can follow their advice, or you don't have to follow their advice. It's your decision. Do you understand that?
Yes.
Okay. Do you have any questions for me about anything that I've said so far?
We have a moment, John.
Sure. No questions? All right. So, Mr. Evans, I'm pressing pause on the conversation at this point. We're going to have the second half of this conversation at some point in the future. I hope it's sooner in the future rather than later, because the last point I want to make sure, and I'm giving you and your family and your lawyers as much notice of this as I can, your case is set for trial September the 10th, and that's not that far away. Do you understand that? Okay. Your case is going to go to trial on September the 10th. So if you change lawyers, you're going to get a group of lawyers in place that are going to have like 7 months to prepare a capital case, okay? So the longer it takes to make this decision...
I'm going to object to what the court has just said. What you're telling him is, right now, that he is basically having to stay with us as his attorney, because if not, then he'll get another set of lawyers that will not be prepared, and they will only have 8 months to do what has taken years to do, and therefore you're pushing him into the corner that he has to stay with us. I don't think that's fair what the court has said.
Over your objection, sir. That's not what I'm saying at all. I want to make sure that you understand that time is of the essence. Do you understand that?
Yes, sir.
Okay. So I'm going to put him back on the docket February the 18th at 9:30 a.m. This issue with the warrant will be resolved at this point, and whatever's going to be distributed to the parties will have long since been distributed to the parties. You all can file whatever additional motions you think are appropriate. If there's any motion that the state wants me to hear, we're going to do that in a notice of hearing. That's by the close of business on Friday, February the 7th. Defense, if there's any motion that you want me to hear, you're going to do that in a written notice of hearing by Friday, February the 7th. If I don't have something noticed in writing by Friday, February the 7th at the close of business, I will not be hearing it on Tuesday, February the 18th. Mr. Deming's case remains set for trial September the 10th at 9 o'clock. State, anything else that I can do for you this morning?
No, Judge.
Defense, with the exception of your,
Yes.
all right, is the state coming up here too?
Yes.
Okay. Mike, this is not on the record. Dan, I think there's a microphone here. That needs to go. Okay, so I'm going to see Mr. Livingston on February the 18th. If you need to get in front of me sooner, just contact my office, although I am starting another first-degree murder trial tomorrow, but that trial may end earlier than I suspect. I'll just play that one by ear. Ms. Wilcox, FT, that concludes FT for today. That concludes FX until 3:30?
Yeah.
Okay, so then the Division FX will otherwise be in recess until 3:30 this afternoon?